All right, hey everybody, how you doing? I thought I'd make a little recap video here just to remind everyone and highlight a few things I think that are relevant and kind of fell out of the topic of conversation and I think are worthwhile to remind everyone about. And originally I started this and set out to make a little bit of a review video, but then I found a few things in some folders that I either missed myself or hadn't really attributed enough significance to. So I added them in here to try to spice things up and find some new things to hopefully bring into the discussion as well. So I hope you enjoy it. I hope you find it informative and helpful, and let's get into it. So I'll start with a little minor recap, and then we'll get into the new stuff. So naturally, a lot of the time, anytime I speak about Bed Bath, or really anyone does, the first thing that comes up is that your shares are canceled, right? There's no possibility for recovery. You're an idiot. What are you even doing? And so we've highlighted this in great detail in the previous videos, but I won't spend too much time on it, but I just want to make sure that everyone's up to speed. So specifically, when we're talking about shares being canceled, we're speaking about shares in BBB, right? So what is that? And that's pretty clear in the plan as we've highlighted here, right? So BBB is the name attributed to the old company before it became the estate, right? Which was Bed Bath & Beyond. But more specifically, it is the parent entity of the former company. And today, and for a while now, it exists as this, right? And we went over this. This should sound familiar, right? It's DK Butterfly-1, which is separate from what I believe is the most significant thing, which is the reorganized debtor, which the PCRs here don't include the -1, right? Because if you look at the structure here, you have a -1 here for these ones. And importantly, this entity, when the global notes are filed for the PCRs every quarter, this entity is not listed in the global notes as the attachment with the 7 subsidiaries that are, right? There are 7 subsidiaries that are isolated, and then there's a separate set of global notes that are filed for like the remaining 65 or 66 or however many of them there are. But importantly, this one doesn't exist in either of them, which is not a surprise, because this entity just exists to pursue the litigation, argue with everyone about adversarial cases, and to kind of sit in court and unwind all of what it's tasked with doing, which when it's done will no longer exist because it will have served its purpose, right? But this entity is not connected to this, which in my opinion is where the new entity will launch from, where the recovery will kind of be tied to, the new interests will stem from, is this one. The reason for that is because the plan man, through his attorneys, admitted as much in federal court. And again, we've gone over this, so I don't want to spend too much time here, but basically says that the DK Butterfly-1 entity is not affiliated with any other corporation, doesn't have any subsidiaries, and is not a subsidiary to another parent, right? There are no such corporations. It exists on its own, which makes sense because it's separate from this, right? And it's separate from the entities that have filed with it on the PCRs, and in my opinion will make up the new company that reemerges one day. Okay. Now, to further substantiate that, so that it doesn't sound like I'm just kind of making that up, I'm not concerned again about the shares being canceled, because in the plan itself and in the findings of fact, in a paragraph appropriately labeled cancellation of securities, it says that in fact the cancellation of securities does not mean that there can never be another distribution, and that's highlighted in the yellow here, right? So in two really things that are really significant here is that one, there's an exemption here that says that we do not have to assume that just because the effective date occurred, nothing can happen, because the first words here are on the later of the effective date and the date on which distributions are made, right? If not made on the effective date. So the one little thing, two things we can debunk here immediately, and again, we've gone over this before, but if nothing had happened before the effective date, it can't happen after, and because your shares are canceled, you can never receive anything. Both are completely bogus. Both are written statements by very, very skilled attorneys charging high, billing hours and, $1,500 an hour or more to make these documents. So I'm going to say that when they write a document, when they submit it to the court and the judge approves it, I'm going to believe what they say. And naysayers on the internet can argue with them because it's pretty clear that, the cancellation of the securities will not hinder evidencing a right and allowing holders of interests to receive a distribution under the plan, right? Furthermore, to substantiate this idea that this entity is different from this entity, which I hope is abundantly clear, The U.S. trustee, when the plan was facing confirmation, this is on September 7th, had made the objection to the plan that the plan should be subject to substantive consolidation. What does that mean? It means that one plan applies to every debtor subsidiary that exists, which is there's 74 of them, right? And as I said a moment ago and before, we should look at three separate groups of entities. You can call them like buckets, or you can call them groupings, whatever. There's DK Butterfly -1 in one bucket. There are the subsidiaries that will not survive, that have their global notes bundled together. And there's the third bucket, which has the reorganized debtor, right, this one, and the 7 subsidiaries that have individual global notes, which again, there's no purpose for that to exist, and why would they be making extra work unless it was necessary, right? In my opinion, the reason that those subsidiaries are preserved must be a combination of either that's where there are significant tax benefits, whether it's the NOL or whether it's, business licenses in the states that they operate in, whether it's Texas or California or what have you. I don't know exactly. But specifically, even though the U.S. trustee objected, the attorneys at Kirkland and Cole Schatz and the judge agreed, because the plan was confirmed, that the plan applies separately for each of the debtors. And the classification of claims and interests under the plan apply separately to each of the debtors. What that means is that this statement of share cancellation only applies to this entity. That is not disputable, right? That is a factual statement written right there by attorneys charging a lot of money for their knowledge and, capability to do so. So this should be very clear now. The U.S. trustee objected, and they were overruled in their objection, that the plan would not be substantively consolidated, and it would continue to apply separately for each of the debtors, right? And as if it could not be more clear, the classification of interests under the plan also apply separately to each of the debtors, a detail that we're going to explore in much more detail throughout this video, right? So further, if you needed any more evidence to the claim I just made, on a separate document, on a separate day, referencing a separate incident, the plan man at this point, because this is after the effective date had occurred, is making the claim here that pursuant to the plan, all common stock interests in debtor Bed Bath & Beyond were canceled, right? Now, I don't want to get too off topic in this video, so I don't want to get into the context of where this came from. You're more than welcome to look it up yourself. There's the docket reference for you. But again, even the plan man is making the statement clearly that common stock interest specifically in one debtor, which is now DK Butterfly -1, and why it uses the notation of BBB, is because the stock interests only for that debtor are canceled, which again is a good thing because it's not going anywhere. It has no future. You don't want it. And what I'm waiting for, and probably anyone else watching this that's had shares into cancellation for Bed Bath, is more concerned about this. Okay, so just wanted to reiterate that canceling of the shares does not mean that you can't receive anything in the future. That's a bogus claim. The plan and everything that it says applies individually and separately to each of the debtors, and so do the classification of interests, very important detail, and further substantiated that that's not a made-up statement by the plan man himself. Okay, so that's going to be the end of the review, and then we're going to get into a few more fun things. So I like doing the videos, and these presentations, because if it doesn't make sense, you can rewind, rewatch, whatever. Ask any questions, go ahead if you're uncertain about any of it, but I hope that makes sense. So going back a little bit now, this is a transcript from a court hearing. And so it says here pretty clearly, this is the attorney, one of the attorneys speaking to the judge, Judge Papali at the time, says that, even though the going concern sales didn't come to fruition, the debtors still have a pathway to a successful exit from these Chapter 11 cases. I just wanted to highlight that because that is a very strange statement to make, right? Especially the use of the word successful. Successful is, an odd placement for a word because, again, it's important to note that this event, this conversation is happening after the IP sales of Bye Bye Baby and after the IP sale of the parent company Bed Bath & Beyond, right? So those are completed. These attorneys obviously are following a plan that's been, brought forward by the debtors and by the advisors and by the professionals involved. Even after these IP sales, even though going concern sales did not happen, there's still a pathway to a successful exit, right? What does that mean? That's an odd word to use if there's not something more to be had, right? And again, I just want to remind everyone the plan that was brought forward for confirmation was not a Chapter 11 plan of liquidation. It was a plan of reorganization, right? And this was not converted from a Chapter 11 to a Chapter 7. So, again, he reiterates the point that there is a path forward, and we fully intend to realize that path. Now, taken individually and separated from context, you may think, oh, well, that path forward is just getting a plan confirmed so that they can dissolve because there's nothing. But that would be ignoring everything else that we just went over, which you can't, because those are very important distinctions that are also made along the way and much later than this one. So you also can't make the argument that potentially they had good intentions in the beginning and then they fell apart, because those statements are made at the conclusion of confirmation and the occurrence of the effective date, right? So another really significant thing that I think is worth a little bit of a highlight again and doesn't get talked enough is back in 2023 when the DIP was being contested and the ad hoc bondholder committee attempted to vacate the DIP with the benefit of hindsight, which was hilarious at the time for everyone that was watching and paying attention. Another statement that was made by the attorneys for JP Morgan when they were surprisingly informed that the ABL had been paid off was that they had requested to remain on as the administrative agent, which was laughed out of the courtroom by Judge Papalia, and he basically said, no, there's no chance, because there'd be no reason that a creditor who was paid off would want to remain on as the administrative agent. But the intent and the reason why they had asked is very significant, and I don't think we should be underappreciating the importance of that statement, because why would JP Morgan want to remain in a role affiliated with this company if they've been fully paid? I mean, as a creditor, that is the ideal outcome, is receiving a 100% pay, in return for your claim when a company's in Chapter 11. But they're very, very interested in maintaining the role. Why? Well, this is why. Because the credit agreement going back to well before Chapter 11 allows for this. Now, at the very top, the credit bidding section and the credit bidding definition is irrevocably only available to be authorized by the administrative agent. And the secured parties, right, which are the lenders and the creditors who have the liens or collateral tied up by their loans, have to ask the administrative agent to be able to credit bid all or any portion of the obligations. So with that context in mind, I think it's very, very obvious, very telling, and would be a huge piece of foreshadowing, not that anybody could realize it at the time, but would be an enormous foreshadowing as to why and what the intent was behind wanting to remain involved, between the process of what was going on in the creditor classes as the administrative agent, is because, one, if they remained as the admin agent, JP Morgan could deny a credit bid, even though they're not owed anything, and the next in line creditor, which is the FILO, has all of the obligations under a lien, they still have to ask the administrative agent, right? And so, as we all know, they were denied. Sixth Street was assigned the administrative agent role, and as we talked about in previous videos, they did perform their credit bid, which is confirmed in the filings for the fee payouts for other professionals that were involved, right? Not really anything else I want to spend too much time on that. Just wanted to highlight the importance of why JP Morgan was asking. And again, just to put into context the severity of the allegedly whatever was uncovered that led to the third-party release, right? Again, there'd be no reason to be looking for wanting to maintain involvement as the administrative agent unless you wanted control. And this very clearly outlines the mechanism of control. And as a little bit of foreshadowing to something that we'll talk about later in this video, the credit agreement that existed before Chapter 11 was incredible, both in its irony and in its role as how things happened and unraveled as they did. So further, again, to support everything else that we're talking about, this we talked about before as well. After the IP sales, no wonder that there could be still a successful exit from these Chapter 11 cases, because look at these definitions of a purchaser and a purchase agreement, right? A purchase agreement saying that you can have an asset purchase agreement that may be amended, supplemented, or otherwise modified from time to time. Now, that language exists on September 14th, right? So even after September 14th, you can have modifications to the plan. And remember, the plan exists independently for each one of the debtors, something that was objected and denied, right? So there is a reason for that. You can't argue that. That is, a fact. Further there, underneath a purchase agreement, you have the definition of a purchaser, right? Which means collectively, as though it can represent a group of investors. Someone could be acting as a proxy or as an agent or an affiliate on someone else's behalf, right? So the legal language to protect all of those provisions. A purchaser under any asset sale transaction, which should be very familiar to conversations I've been trying to have with everyone for years about the third-party release and how important it is to the outcome that I believe all shareholders that held into cancellation are waiting for. In my opinion, the key and the most important component of it all, language that again cannot be refuted, an outcome that has legal protections in the language that would not exist if it were not to happen, which, as we also see previously from the plan applying individually to each of the debtors, it should all make sense, right? So again, a little bit more because, sometimes when not sometimes, all the time when I speak about, the Bed Bath estate and the company that used to exist, everyone says I'm crazy. Everyone says I'm an idiot. So let me just give more substantive confirmation of the claims that I'm making, that on September 7th, as the plan was approaching confirmation, the debtors applied for a waiver of a 14-day stay, which is basically a pause that happens normally after confirmation for 2 weeks where nothing usually happens, right? They apply for a waiver. This is not nothing new. But again, the language is really, really important. And similar to how we talked about transactions and, how the plan applied separately for all of the debtors, this is a statement made on September 7th, right? The IP transactions for both Bed Bath and Bye Bye Baby are complete. So what complexity, right? Let's look at the red underlined section. Given the complexity of the plan and the various transactions implicated by the plan, what are you talking about? There should be no complexity if there's nothing else to sell and it's just a liquidation. And there should be no more transactions because everything was already liquidated. And if there's no outcome to be had for anyone, it's done, right? Again, language that exists intentionally, that cannot be refuted, that anyone arguing against should debate with attorneys making, $1,500 an hour to make these statements because, again, I choose to believe them and the submissions they make to a federal court over naysayers on the internet. So very important to recognize, furthermore to the plan applying individually to each of the debtors and the shares only being canceled for one of the 74 debtors. On September 7th, everyone is saying that there's still a lot of complexity to the plan and various transactions implicated by it. In my opinion, I believe those to be the third-party release and the resulting asset sale transaction. Okay, but again, language that should not or would not exist unless it were necessary. Again, just here now, so how does it all relate, right? Because as time went on, we saw that the credit bidding did occur. And if you look below page 147 here on the next little section, the bottom half, that the agent, who's the administrative agent, can basically issue to each of the secured parties whatever they want to bid on, whether it's partnership interest, equity, interest of, lien, collateral, whatever. They can take whatever components of what they own, they can assign it to whatever secured party they wish, and no one else has to make any other disclosure, right? Because everyone's wondering why. Why is this taking so long? When is this going to happen? I have no idea, and I'm not intending to predict anything. But I just want to make note that even though nothing has really come out otherwise to say, hey, so-and-so is involved in this, it's because the credit bidding procedure and the credit agreement that existed for this company says that things are going exactly how they should. Sixth Street, as the administrative agent that had completed the credit bid, can prepare all of the assets and all the collateral that they want to distribute to their secured parties, and things can just kind of relax until they're ready, right? And I don't know when that moment of readiness is going to be, but this explains why things are up until today, which is, the point of which they are at. Now, anyone disagreeing with me on that statement is going to say, well, no, the credit bid can't happen. There's nothing left. Again, nonsense, which we've gone over in great detail in the other previous 3 videos, but this is a resource from the United States of America Department of Justice website, which plainly, clear as day, says that things aren't over. And you cannot make a factual statement that as it stands today, there is no recovery coming for anyone. There is no possible outcome other than whatever they want you to believe. And the website here says clearly that after a plan has been consummated, you do not know the outcome until a final report is filed and the case is closed, right? So you have confirmation, then you have consummation, which takes however long it may, because again, the plan says on or after the effective date, whichever occurs later, right? Once the consummation is completed, then a final decree is filed, and then the Chapter 11 is closed, right? So since a final decree has not been filed and the case has not been closed, you are not making a factual statement by saying that there's no possible outcome for anyone. You're making an opinion, which is fine. Everyone can make their own opinion, but it should not be passed as fact. Again, this is a direct source from the Department of Justice website for, I think, explaining Chapter 11 cases. So again, I want to highlight two other things that are going to support what's going to come from that reorganized entity, right? We're going to talk about a section 1146 and a 1145 exemption in reverse order, and I think it'll make sense why we're doing that when we're done. But section 1146 exemption, again, a statement that is in the confirmed plan for the estate of Bed Bath & Beyond that says that any transfers of property, right, which are defined in the asset sale transaction, which again is stated in the next few words there, or the issuance, transfer, or exchange of any security under the plan shall not be subject to a tax, right? That is the section 1146 exemption. That is not ambiguous or vague language. In fact, if you go to the Cornell Law website, which has all these definitions, it's pretty clear. You invoke 1146 when you have an issuance, transfer, or exchange of a security. Again, apply that with everything else we discussed. The plan applies individually to each of the debtors. The interests in BBB, strictly and specifically, are the only ones that are canceled. And DK Butterfly-1, which is what BBB became, is not part of the reorganized debtor. But again, there would be no reason for this language to exist in the confirmed plan if there were not to be issuance, transfer, or exchange of a security. Clear as day, right? We further see evidence of that in the fee filings for the special counsel hired by the ad hoc bondholder committee, right? Plain as day, they are building time for research concerning the structure of a post-confirmation entity to preserve NOLs. What does that mean? That means an emerging reorganized debtor. Importantly, I didn't highlight it, but that statement is made on August 2nd, after the plan has gone out for voting. Okay? Not something that had been, drummed up in April or May and had to be abandoned by the time the plan had come out. A post-confirmation entity to preserve the NOLs. That's a reorganized debtor, right? Again, another statement here, talking about net operating losses at the debtor and the reorganized debtor, and the impact of a proposed rights offering on that. Now, what is a rights offering? A rights offering is the issuance of warrants, for example, which is a type of security, right? It can be the issuance, the transfer, or exchange, right? But there it is, plain as day. There's discussion of a rights offering to what I believe is the reorganized debtor, which is not DK Butterfly-1, which has nothing to do with the shares canceled in that entity, because 1146 can be offered as an exchange, right? Another example to say the NOL preservation structure and related rights offering issues. Again, these guys, you have to, when you're talking about issues, you have to understand their angle. Their angle is working for their client, who is the ad hoc bondholder committee, who is trying to prevent the plan from being confirmed in the manner that it existed when it was presented for voting, in my opinion. That's pretty clear when they show up and they want to vacate the super senior creditor protections, liens, and hold on assets. In hindsight, when they see that there was a couple extra bucks on the balance sheet as a result of the liquidation sales. But again, something that's irrefutable. There it is right there. More reorganization updates, not liquidation updates. Reorganization, NOL preservation, again, for an entity that is the post-confirmation entity, which is a reorganized debtor. Okay? I hope that's very clear. Now, let's go from 1146 to 1145, right? What is a Section 1145 transaction in, there it is again, a plan of reorganization? Well, it's this. It is the exemption for making SEC reporting up until the moment you are ready to make your issuance, right? And it says here, clear as day, we've gone over this before over the years, that to the extent that beneficial interests, right? Again, interests, very important word, in the liquidating trust are deemed to be securities, right? Remember, Section 1146 and something highlighted in the confirmed plan as well. Same document as where this snippet's taken from. The debtors intend that the exemption provisions of 1145 will apply to these beneficial interests, which what that means is when they offer their rights offering, right, that they will not have to make a filing ahead of time or similar disclosures like an IPO or whatever until they're ready to go, and they basically don't have to give everybody a lot of notice. Again, just to remind everyone, interests are the key, right? there's a division here that I need to really draw a clear line between DK Butterfly-1, DK Butterfly, the reorganized debtor, which has the PCRs of the other 7 subsidiaries in it, and then there are the PCRs of the 65, 68, I don't remember how many, sorry, other entities that are, in my opinion, just basically unneeded, unwanted, and will be dropped, right? We've gone over it before. DK Butterfly-1, the entity that is in court, has no affiliation with those corporations. Remember, the plan applies individually, and so you should not be concerned with anything that the plan man is saying because he represents this entity, which has nothing to do with any of the other entities. As a little reminder, go back to the other videos, look up the third-party release, look up the general account, everything will make sense. Yep, another reminder. Sorry, I don't make notes, so I'm just going on the fly. But the reorganized debtor, DK Butterfly, does not have a -1. That's on purpose, because they are the reorganized debtor, and not these guys. Because these guys won't exist. These guys will. And they're going to offer a rights offering, and have their NOLs preserved, and be a post-confirmation entity made up of these guys. Again, really important to note that when they're making the PCRs, when they are preparing these quarterly financial disclosures, there would be no need to add extra and additional work to make global notes for these 7 subsidiaries, independently of the remainder of them, if these weren't the ones that were going to be part of the reorganized debtor, in my opinion. So that's, I guess, the end of like the review and the half review. Excuse me. I'm just getting over being pretty sick. Now I just want to go over a few things that I found that either I didn't attribute enough attention to, or some details were missed that I want to share that are pretty cool. So one of them is from the class action against RC, the activist, that was brought forward. And this is a disclosure and a conversation between Mr. Rosenzweig and Ms. Lombard, who are 2 of RC's appointees that resulted from the cooperation agreement. And if I'll have you look at the date there, on August 17th, they are making a discussion about a restructuring, which is many, many, many months ahead of when the restructuring actually came. Previously, I had been of the opinion that the restructuring was decided either in December or January, when a few things happened. Notably, there's an offer made by RC for $400 million for the company. Mr. Rosenzweig will leave the board. Mr. Kasten will join as the company's general counsel, and then in January, a bunch of funny things happen. Like, for example, Overstock signs a cooperation agreement or a confidentiality agreement with the company. All of the company's directors have their RSUs taken and given back. Lots of other things. Mr. Tritton suddenly has a severance. They call him and say, hey, sorry, we can't pay you. We'll get into that in a little bit. But now we can rewind the clock a little bit, because what's peculiar is this is a period in time where the Philo lender is already in the picture and is doing some research, and we're going to talk about that in a little bit as well. So to think that the Philo lender had shown up and would not know about a restructuring possibility is crazy, and further solidifies, in my opinion, that the Philo lender, Sixth Street, is one of the affiliates or acting as a proxy for one of the good guys, for lack of a better word, and just existed to secure the liens and collateral for the acquirer, who will eventually be the purchaser, according to the purchase agreement, according to the asset sale transaction, according to the third-party release, which, I'm sorry, I know I promised I wouldn't hammer it home. But very interesting to find that the restructuring conversation already exists in August. And we're going to get into a few other really exciting things that happened in the summer of 2022 as well. You'll remember this from one of the previous videos. Very startling to me to see that the global vice chair of shareholder engagement and merger and acquisition for JP Morgan, in, I believe, the largest financial institution in the world, was hired specifically to advise about an activist for this company. But something that really I hadn't considered was that he was advising the company from very early on. You'll notice that this email chain is in April. This is exactly 1 month after the cooperation, well, not exactly, but approximately 1 month after the cooperation and standstill is signed by RC Ventures in the company, right? So what I want to point out here is, one, how early the advisement of JP Morgan against the activist was. And second of all, it's startling to see that the advisor is drafting communication with the activist on the board's behalf. And the board is seeking advice on how to communicate with the activist instead of just doing it themselves. Hilarious. Further, excuse me, I'll go back to June now. I want to make something, really highlight something that I completely missed before, and on a second, third, fourth read stood out to me, and that's that this is a response to RC, who had written to the board saying, hey, we need to get more of my candidates on the board. We should make the board smaller. I want more people put on. He's basically trying to shake things up. In my opinion, he wanted to get a majority vote from the board in favor of his intentions, which were outlined in the cooperation agreement. He didn't have a majority vote of the board as it existed, so he wanted to make the board smaller, bring in more of his own candidates to make sure that he could get a majority, because New York corporation law basically prohibits an activist from doing anything if you can't get a majority vote by the board. But in that response to that email, within the company, there's a very, very cool conversation here. They're acknowledging that he wants to have more candidates, but they say that he cannot, other than the 3 that he already has by Ben, Marjorie, and Paul. Now, this is either a brain fart or a huge, huge clue and admission as to what was happening here. And I don't think it was a brain fart, because RC's 3 board appointees were Ben, Marjorie, and Shelley. Right? So not really someone that you would confuse for Paul. Now, you may say that maybe Ms. Hong writing this email was thinking about Paul later in that sentence and she accidentally wrote Paul again. Maybe, but I have a few good little pieces of evidence to dispute that and that dismissal, and I do think that this is intentional. One, actually, first let's go over who Paul is, and then I'll share my little information. But so Ben, Marjorie, and Paul, right? We don't know of a Paul that is on the board representing RC's interests. So who's Paul? So this again is the response to the original email, which is on the bottom. But you'll notice I've highlighted a Paul, a Mr. Paul Shim. Now CGSH is Cleary Gottlieb, who is the law firm that represented the company in 2022 and before. Now, who is Mr. Shim? Well, he is an attorney over there. But he's not only any attorney, he is the attorney that signed and wrote the cooperation and standstill agreement on behalf of the company with RC. Not only that, but as fate would have it, Mr. Shim is a very specific and qualified lawyer in which field? Of course, none other than being the co-leader of Cleary Gottlieb's M&A group. Okay, so to dismiss this as coincidence, sure, maybe, but in my opinion, it's very intentional, and I'll tell you why. I don't have one piece of information here that you can look up, but if you don't believe me, but trust me. In one of the depositions, I believe it is a deposition of Miss Shelley Lombard in the RC class action, one of the evidence exhibits is an email that she sends to a former colleague of hers as a reference, requesting them to act as a reference for her appointment to the board. In that email, and I'm paraphrasing because I'm going off memory, she says, hey, you may have seen in the news that, this activist has joined this company. And then her next sentence is, what is not public is that the company is collaboratively working with the activist to refresh the board and transform the company from the ground up, right? So that was something that was shared by her outside of public, whatever was reported to the news. But in my opinion, the combination of Paul being mentioned in named in the context of not adding more board members for RC, Paul also being the attorney representing the cooperation agreement, him also being the co-leader of the M&A group, Miss Lombard stating an email that the company is looking to refresh the board and transform the company from the ground up, and one other really valuable snippet is in the same class action, Cleary Gottlieb, although being a legal representative of the company of Bed Bath, when requested by the plaintiffs of the class action, makes a legal statement to say that they do not believe that RC Ventures and RC as the activist are bound by a Section 16B violation. Again, without being his legal representatives, they are trying to quash the class action back in 2022, when the original plaintiffs, Todd and Judy, had made the request to the company to confirm the trading activity. Cleary Gottlieb, and I believe his name is Mr. Jared Gerber as the attorney, but don't quote me, made the statement and officially put it in the court record that RC is not bound by a Section 16B violation. Putting all those together, I don't believe that mentioning of Paul here as a board member representing RC's interest is any coincidence at all. I believe this originally was intended to be a collaborative takeover of the company to try to refresh the company. And when the legacy board for allegedly Reasons like trying to cover their own butts for the share buybacks and the October 2020 plan and the ASRs, which we've talked about in great detail. They kiboshed it. They tried to prevent it from happening. I wonder, in my opinion, allegedly not making any claims. But very cool to see Paul mentioned as one of the representatives for RC, the activist, and Paul being the attorney that wrote the cooperation agreement and also having the qualifications that he does. Very cool. But a few things are happening at the same time. So let's look at the chronology, right? Just mentioning this here because the strategy committee, which was made as a result of the cooperation agreement, realized a few months in that they could not isolate buybuy BABY from the parent company to conduct a sale or spin-off or what have you. I don't want to get too tangential, but it turned out that one of the problems, on top of many other ones, was that the books were too intertwined. There was no way to appropriate a valuation for buybuy BABY because the accounting was so screwed up. It was completely backwards. By June 28th, excuse me, and I don't know if this email is written before or after RC finds out that Mr. Tritton will be fired as the CEO, because this class action does reveal that he found out the night before. But he makes this communication basically saying, if I can't get into position, I may sell my stock, right? Because again, he realizes that if the board can't do what he wants, he needs board members that will offer a majority vote for the things that he's intending to do. And if he can't get a majority board vote, he's a sitting duck. There's no point of him having his shares. And eventually that's why he sold them, right? But this is also very interesting in a chronological lineage here because we're looking at June 28th, right? Where he's like getting fed up. He wants to sell his stock, right? But again, I want to just mention the conflict here between approaches with the activist and Mr. Tritton, the CEO. Multiple times, according to this conversation, going all the way back to April again, there's discussion about bringing the activist, as they call, under the tent, which is under an NDA or under a confidentiality agreement, to work collaboratively and together to get a grip on the spending, get a grip on the cash flow being, flying out the door, and trying to right the company. Multiple times, the CEO is against offering that to the activist, right? We don't know why, but then the next message is regarding stock buybacks, coincidentally, or not. And after a while of looking at it, that little message that's blocked by the arrow says, yeah, and I get it up until FYE, which is fiscal year end. March is inexcusable, referencing the stocks buybacks. Pretty clear what the confusion was with where the capital spend was going, right? And we'll get into stock buybacks in a little bit. But going back to this email chain, Mr. Tritton responds in an email to the strategy committee, which kind of laid out meeting minutes, and he says, hey, I'm kind of concerned. What's going on? I don't know anything about this. Again, don't want to get too tangential, but I just want to highlight the division within the boardroom itself, where by June 21st, Ms. Edelman and Ms. Gov are basically not updating the CEO on the findings of the strategy committee, and it's becoming rather adversarial amongst everyone amongst the board, around the board. And within a week, the CEO was terminated, right? Or so, according to the news release, resigned. What's funny though is if you go back to June 28th, when RC was saying, if I can't get into position, I may sell my stock. In his own deposition from the class action, it's revealed that he had considered buying shares on June 30th and July 1st, right? He wanted to increase his position. Now, the standstill agreement allowed him to increase the position up until 19.9% ownership, right? Why these days in particular? Well, because June 29th was the company's earnings, and the financials were terrible. The company was depleting their cash pile, as we all know. The debt was piling up. The private labels that Mr. Tritton was kind of, pivoting the company to were a miserable failure. And the company was basically not doing that well, as you can see on the stock price reflecting it, right? Before earnings, after earnings. But again, the reason I'm sharing this is to highlight the conviction that the activist had to acquiring shares of the company and wanting to right the ship and wanting to work with the board or replace the board and work as a shareholder activist if the board was not going to cooperate with him before pivoting, in my opinion, to a different position from his shares, which is why he sold. Because another really remarkable piece of information that came from the depositions of the class action is that the board was aware that by July 15th, there was a FILO being considered. Now, this is much earlier than originally I had known that the FILO was in the picture. Originally, as a follow-on statement released in an 8K to RC selling his shares, the company says, hey, for several weeks we've been working with a lender, yada, yada. We're trying to reposition ourselves and rebrand and come out of the ashes here. And we're going to release a statement in the near future. But I did not know that that extended all the way to July 15th. But this admission here in the deposition is that by July 15th, the entire board was aware that they were shopping FILO lenders, right? So here's something really important. RC, as a very, very involved activist, wanting to know everything that he can without getting revealed MNPI, right? He's very clear about that, wants to help the company, wants to work collaboratively with the company, cites the cooperation agreement saying, hey, we are a team, we need to have mutual respect, we need to work towards maximizing shareholder outcomes and the best, most prosperous way forward for this company. A guy who's very, very meticulously hands-on suddenly goes dark. And I have a few screenshots here from depositions that basically confirm that on July 15th, right, the same day that the company or the board is aware of a FILO, that is the day that RC stops communicating with the board, right? Why would he do that? Well, that's actually the really cool thing that I wanted to share today. Another confirmation here that there was basically no communication except for trying to book a trip to Florida with RC as of July 15th. More confirmation that he went dark, not communicating with anyone. No. Any communication? No. Emails? No. Zoom calls? No. Person meetings? No. Why is this stage being set? Because RC and his attorney, Mr. Neville, brilliant, very, very intellectual, very intelligent two people. They are making sure that there is a paper trail to confirm that they were not communicating with the board. Why? Because suddenly, when RC wants to sell his shares, JP Morgan says, hey, you can't transact until you confirm that you're not an insider, or you update your filings with a Form 3. So what does Mr. Neville do? RC and Mr. Neville, they're saying, hey, why can't I trade? Why can't I trade? Famously, the attorneys for the class action on the plaintiff side try to say, well, why are you having such urgency? Why did you want to trade right now? Why did you want to trade right away? They're brilliant. They say that when they found out that he had to make the filing, he did make the filing. Right? He filed the Form 3, he filed the 13D, therefore he's considered he's considered an insider, right? The dates are important here. The confirmation is, right, RC is saying, hey, I need this resolved tonight so that I can trade tomorrow, right? Why is he so adamant on trading tomorrow? Tomorrow being August 16th. Well, because August 16th is exactly 30 days and one additional day from July 15th. And why is that important? Because the SEC released a bulletin basically saying that if you're a Form 3 filer or a Form 4 filer, you have specific cool-down rules before you can sell your shares. Now, RC filed a Form 3, but he was not subject to a trading plan, obviously, because he did not know that he was an insider, right? But still, despite that, it's a brilliant move. And again, I'm not making any allegations. I'm not saying that anyone knew anything before they publicly disclosed it. But exactly 30 plus 1 days later, after filing his Form 3, RC abides by the cool-down period of 30 days for persons other than issuers or directors and officers before any trading can commence. Brilliant. In my opinion, and my interpretation, is that the attorneys for the plaintiff for the class action are trying to allege that RC was tipped off about the FILO from his board appointees, and he knew that the debtor and the structure of the creditors was going to change, and he knew that there would be more debt put forward before bondholders would have any recovery. And their allegation is that once he found out about the FILO, which was either at the same time or before the board did, he stopped communicating so that he would fall in line with his 30-day cool-off period, and then would be able to transact having insider information. Something that clearly was not proven because the class action was dismissed. Now, again, I'm not making any allegations or saying that someone did know something or didn't know something. I wonder if RC, between June 30th and July 1st and July 15th, realized that the board wouldn't work with me. I also can't put any more of my own people in because the standstill agreement says that I can't make changes to the board. So immediately he realizes if he can't change the votes of the board, or if he can't change the composition of the board to get the votes that he needs because of the standstill, he's a sitting duck. He can't do anything as an activist shareholder, right? So sometime between July 1st and July 15th, I believe, he realizes this, and he makes sure to either reposition himself through Sixth Street as a final lender, as a proxy, or through an affiliate, or through someone that would, little foreshadowing, be considered as qualifying as an investor group, or he just pivots. The timing is coincidental, or it's intentional. Whether RC is involved with Sixth Street by proxy or through affiliation or through another investor representative, I don't know. But it's very telling to me that he was very involved with the company and wanted to get more involved, and then goes dark exactly 31 days before he sells his shares so that no one can consider or accuse him, I guess, that he was filing as an insider, not abiding with the cool-off period. Another little fun find. Let's get away from that for a sec. Is when he did sell his shares, immediately after the filing, that his the 13D, excuse me, 13D filing where he's denouncing his position, the CFO of the company emails immediately saying, "Hey, I'm concerned. Why is JP Morgan involved in the selling of the activist's shares?" Random. I'm not really sure why this came up, but I mean, we all know what happened. We all know, no, actually, I allege and I wonder of the opinion, what happened with the ASR, what happened with the ABL, what happened with the 2020 plan, all of which was hatched by data and financial disclosures and financial projections that the CFO had presented to the rest of the board, which got them to vote in favor of the buybacks. Why is the CFO concerned about JPM's involvement with the sale of the activist shares? I don't know, but it stood out. So then we go to the ABL itself, right? Which, if we're pivoting back to the October 2020 plan, I think it's really important, and don't worry, I'm going to come back to my theory about RC repositioning himself away from being a shareholder and looking for another avenue. The ABL comes at no surprise in hindsight. The October 2020 plan, we've gone over in great detail. Look when the ABL was formed. Months before, in June, right? So in June 19th, the ABL is made, allows a much larger borrowing base for the company, much larger debt load, right, that they can carry. And look what happens a few months later. Now, that $225 million number we're going to come back to, very important number. But mere months after the ABL is made, the company announces this October 2020 plan, which we've gone over in previous videos, in my opinion, stood out to RC like a sore thumb, and he was not a huge fan of. And let's just take a look at a quarterly snapshot here. I'm not going to do every quarter, just what was filed in the 10Ks. This is before the ABL. This is after the ABL and the October 2020 plan. An enormous difference. This, again, is leading up to when RC was buying his shares, right? And we famously know his position of 9.8% versus the increased ownership, even though there's a problem there because the cooperation agreement is signed by the CEO with RC having 9.8% ownership, even though the CEO knows it's not 9.8 because he was authorizing the buybacks. And then by the time that the company really only has one possible outcome, which is to try to reposition itself through a strategic restructuring, the share buybacks are gone, but very concentrated purchasing. Why? Right? Well, we've gone over it in previous videos. I don't want to go too much into it, but I just wanted to highlight the timeline again of the intent there, in my opinion. And I guess I don't know why I included this. Oh, I included this to highlight that the pivot to the private brands was recognized as an enormous mistake. Customers stopped coming to the stores. Items stopped being sold. They had traded their shipping lines and their vendor relationships at period during COVID when those were very difficult to do, and abandoned all of their vendor relationships for these private brands which were not selling, which then they had to liquidate. And we pile on, right? This idea of take on an ABL, so expand your debt lending, your lending capability, your credit facility, deplete your cash pile with buybacks, load up your debt to finance these private label goods. Private label goods aren't going anywhere. You have no more cash to reposition or re-inventory back into the goods that customers love. You're stuck with a lot of debt. You don't have a lot of cash. Your product's not selling. What can you do, right? Furthermore, in August of 2021, the ABL is expanded. I think it went up to 1.13 billion, right? An enormous number. All of that. Eventually, this is the 10K filed in 2023, which was very, very late, but a lot of focus on some of these losses of the previous years that we've just discussed. I believe the Kirkland attorneys were the ones that wrote the 10K for the company, and they did not shy away from highlighting the losses as a result of the decisions going back to 2020, as we see highlighted there. So, how ironic, okay? We talked about the timeline of RC really wanting to purchase shares as late as July 1st, going dark by July 15th, a stark contrast to his previous, hands-on direct involvement with the company. And then there's, Sixth Street's kind of showing up to try to, take a position and further the company's debt. And I think it's hilarious because, I'm not sure how it played out. We're just speculating and telling a story, but it's incredible how Sixth Street was able to enter the picture here as a FILO, which JPM, I think, loved because it was, more debt for the company, but it was junior to their own debt. So they knew that, if anything were to happen in a Chapter 7 scenario, they get the assets because the ABL guarantees that they would acquire whatever it is they wanted, right? So you have the lethal combination of the ASR from the October 2020 plan, depleting the company's cash while piling on debt, while piling on their warehouses and shelves with inventory no one wanted. And all this time, when the ABL was made, it was the original ABL that allowed a FILO to come in front of the bondholders. And so it should be no surprise why the ad hoc bondholder committee may have been a little bit upset and trying to retroactively, with the benefit of hindsight, vacate the dip. But of course, they were unsuccessful. But I found, reading the credit agreement like a weirdo, I found that the FILO loan provision was put into the original ABL, and Sixth Street very tactically, I think, positioned themselves as the partner of the affiliates and proxy, in my opinion, to make sure that they position themselves to the amount that was provided in the original ABL. And we all know what happened, right? They come in as the FILO, not less than, in less than 1 year from when they come into the FILO, the ABL in its entirety is completely paid off, with the help of HBC and raising a ton of money, which we're going to get into next. I don't know why I have that there, but let's move on. Oh, I guess this is a highlight for the timeline that we just went over, so forgive me. I kind of sped run that. So we're talking about, from July 1st to July 15th, then the FILO's there, then he's not, liable for the share sale because he waited exactly 30 days. And then again, something I want to highlight is exactly 61 additional day after RC sells his shares, there's a bond exchange that's offered, which ultimately is unsuccessful, which again makes no sense because if you're a bondholder, and if memory serves me at this point, the bonds were trading 40 cents on the dollar already. There was a lot of default risk. If you're a bondholder and you own bonds to hopefully recover your principal at maturity and collect interest payments before, you would be in favor of improving the company's balance sheet so that they could perform a turnaround. And yet none of the bondholders had agreed or said that they would convert their holdings into these, further back debt notes that would have provided the company with a better balance sheet position to obtain more credit and obtain money that they desperately needed because they spent it all on buybacks to be able to correct the business. However, why did I say 61 days? Because if you look into the rules, if you are an insider or if you are an activist investor and you get out of a position, you have to wait 60 days before you try to approach from another angle. Now, in the meantime, we had Sixth Street, right? Which, if they are an affiliate, I don't know if they are RC because I'm not sure if he would be allowed to be a shareholder and have a partner come in as a senior creditor at the same time. That would be a representative of his by proxy. I'm not actually sure. Maybe he can, but it's notable that exactly 61 additional day later, these show up. And although they are unsuccessful, one thing that did happen as a result of these is that there was one individual bondholder who did not exchange their bonds, but actually retired them and exchanged them for shares. And so the company was able to mature and wipe out those bonds at no cost to the company because the private person had taken shares, became a shareholder, and so they paid them in shares. And this investor also gave the company $3 million additional dollars on top of their bond holdings to convert to shares. Now, that makes absolutely no sense unless that bondholder turned shareholder is positioning themselves and needed that additional $3 million of cash for more shares to, meet some sort of a percentage position, in my opinion. Something that doesn't get talked about enough, and I think is worth another look. Notably, 2 days after that private shareholder does that bond conversion, a group of institutional investors follow, and they submit their bonds for maturity and receive shares in return as well. Again, doesn't make much sense unless it was a failed kind of, becoming a shareholder. But that in and of itself doesn't make much sense, because why, if you are trying to pivot to make a move on a company, would you make yourself more junior in a recovery scenario? So that doesn't make sense unless it's intended to structurally position themselves in a very specific way up to a certain percentage ownership. Otherwise, the additional $3 million makes no sense. So we mentioned an investor group at the beginning of the video. And I just pulled this. This was a really good summary that I could not have described better. So I just pulled it off of Google. But if there is an affiliate or a proxy or someone investing alongside RC, the original activist, they could qualify as what's called an investor group. And we went over this 3-year look-back period in a previous video of mine that I did, and in some posts going back to the summer, where if you want to preserve the NOL and you were greater than 5% shareholder, if you take a 50% change of cumulative ownership, right, you trigger a change of control, and you lose the NOL. And so in order to do that, to make sure that you don't trigger a change of control and keep the NOL, you wait 3 years, right? However, the term investor group comes up because, and I'm just putting this out there for speculation, for good discussion, and for people to put their thinking caps on and brainstorm. If there is any sort of relationship by proxy, affiliate, or anything that would match under what's called the dealer-manager agreement, which is something that also doesn't get discussed enough nowadays, that Lazard made on August 10th of 2022, which we now know overlaps not only RC, but Lazard as the financial advisor to the company, and Sixth Street as the would-be, soon-to-be FILO lender of the company. If any of those are affiliated, and if there's any sort of affiliation by the investor that purchases the bonds and retires their bonds in 2022 for shares, whether by proxy, dealer-manager agreement, or affiliate, they may qualify as an investor group. And any one of their investments or decisions would be subject, in my opinion, to the 3-year look-back. And so I wonder, and I don't know, if it was always going to be 3 years. If it had to be 3 years because of how they had to pivot and go from one strategy, which was RC as a shareholder, not getting cooperation from the board, whether Sixth Street's involved as the affiliates, I don't know. I suspect that they are, because their role is probably to just put a blanket lien on the assets to make sure no one else could come in. And it's very odd that someone in November of 2022 would act to retire their bonds and take a more junior recovery position and pay the company an additional $3 million on top of the bonds that they owned for more shares. If those are at all affiliated with RC, since RC was a greater than 5% shareholder, they would all be subject to the 3-year look back, and you would have to wait 3 years until any and all of them were outside of a 3-year window for their last transaction before you could perform any sort of transaction on the reorganized debtor entity without triggering a change in control, which would make you lose the NOL, which Judge Kaplan had the little slip in the confirmation hearing to say that the NOL was being used, and then he corrected himself to say, potentially. But we all know that that was a little slip because he had just read the notes because he was filling in for Judge Papalia. So I don't know. I just wanted to put it out there that maybe it had to wait 3 years from the end of November all along because of this requirement. And that's why this is on the screen for so long. So think about it. Let me know what you think. Would love to hear your thoughts. So let's go back to this $225 million number, right? Very, very important number. Because exactly the same number that comprises, sorry, forgive me, my English is not very good looking today. The same number that makes the first ASR is exactly the same number that the company will seek from HBC when they are up the creek with no money, with their bank accounts seized under cash dominion, and with their bondholders being late to be paid, and they are in default, and they are in the middle of a grace period that JP Morgan is oddly trying to not even allow them to have, and to put them into insolvency before the 30-day grace period for paying the bond note. guess what? A fairy tale outcome comes true, and suddenly there's an investor group that wants to fund the company with a ton of money, right? And I want to make mention, this is a Bloomberg article from February 7th of 2023, which is the next day after the offering. Famously, we know that the company raised $225 million from HBC, right? What I did not know at the time until I saw this article on Bloomberg was that at inception, on day one, the company and the underwriter gathered enough institutional investor interest that they had the entire $1 billion of the offering covered. And yet, despite the company having no money, a mountain of debt, being in cash dominion, not being able to pay their bondholders, they don't take the full billion. In fact, they don't even take 800. They don't take 500. They don't take 600. They don't take enough that would have paid all their creditors, which they potentially could have. They don't do it. In fact, all they take is exactly $225 million, which you may make the argument that, well, maybe that's all they needed. That argument would be incorrect, because on the same day, Sixth Street also pledges another $100 million. So why did the company not take 325? Well, in my opinion, the real reason that Sixth Street put in another $100 million is because they did the math and they needed to come up with the correct proportional ownership of each class to make sure that they could acquire this company, and that this was a strategic acquisition through a strategic restructuring going back either as far back as January, December, or August of 2022, in my opinion. I found it remarkable, and I really wanted to share, that the company had the entire $1 billion right at the beginning, and they didn't take it. Wild, right? What's more is that as a result of accepting the ending of the credit default, the company had to agree to a new negative covenant on their ABL from JP Morgan that said, if by the 7th day of each month you do not have enough money to run your operations for the entire month, we are immediately declaring you insolvent. And the company agreed. And HBC came back on March 7th, exactly 30 days later, on the 7th day, to again provide another $135 million so the company could get through March. Why? Right? Why did they not just take the full $1 billion right away and try to transform the business? Because the board didn't change. RC could not put his board appointees in position. He could not get the board reduced. At this point, he had made a $400 million offer on the company in December of 2022, something that's ridiculously refuted by naysayers. So they make the claim that because RC did not say it himself, it's not true, which is, I mean, you got to be a few fries short of a Happy Meal to make a statement like that, because a deposition is a statement under oath. It's basically the same as being in court. And unless your attorney objects to you answering, you have to answer truthfully. So any statement made in a deposition is a truthful answer. RC had tried to purchase the company for $400 million. The board had not changed. And so what does this say about HBC, right? Who are they representing as a proxy? As, you know, who are they acting for potentially as one of the affiliates? I mean, they have more than enough money to right the ship, right? Which was the plan in August of 2022. But the top of the company, the board, is not different. And in my opinion, they knew they were not going to be able to transform the company according to plan A. Then they tried plan B, which was the bond exchange, and they knew that the bondholders were not interested in transforming the company. And so they had to go to plan C, which was a very clever executed restructuring that resulted in the transfer of the ownership of the asset sale transaction through the third-party release, which we are yet to see the result of, because what did we say? We haven't had a final decree, and the case is not closed. But this was a remarkable find that I just wanted to share about the $1 billion and why they didn't take it. So I just added this as further support that they needed more than $225 million, because in the lawsuit of Mr. Tritton against the company for taking away his severance, there's an admission by Mr. Caston that the 225 was just going to correct the default on their ABL loan. So why wouldn't they take more? And they acknowledge that there's another $100 million required as well to go towards the debt of the ABL. And yet they only took 225. Incredible. So why would they do that, right? Well, I don't know. But they made a really clear point to discuss it in the 10K. Just like they were talking about those losses in fiscal 2020, 21, and 22, they're talking about a lot of things here. Not only this is out of order, so forgive me here. There it is. They also make mention of something else. Actually, let me just go back here. Sorry. There it is. On February 7th, on March 6th, on March 30th, right? The company basically says, this is what we're doing. And then, after getting the $135 million on March 6th, they pivot away. They part ways with HBC, and then they try to enter another at-the-market sales agreement. They're basically a copy and paste of the old one with another provider, B. Riley, this time. However, that March 30th one, despite the company needing more money by April 7th, which they must have received from somewhere, they do not activate this ATM. And this was either a fake out or just set up and not needed. But I don't think it was anything other than a fake out, which we'll see in a second, because we have an issue. On May 9th, the company says how many shares should exist. And famously, there's an oopsie, because more shares exist. So everyone will remember the talk of the reverse split, the ATM being with HBC, then another mirror ATM happening with B. Riley. What's not very well known is that there's a personal injury claim that comes into the public view in 2024, I think. And it highlights in its evidence, to try to substantiate the claim for whatever reason, a personal injury claim attorney writes to the company in March of 2023, sometime at the end of March, requesting the equity shareholder list, this document. Importantly, the company had not yet filed for Chapter 11. And a personal injury claim person is wanting the equity shareholder list, which is a requirement, I believe, within 20 days of filing for Chapter 11. I don't remember, don't quote me. I'm just going from memory. Why would a personal injury claim person and their attorney want an equity shareholder list? Who knows, right? That's why I love this, because there's so much drama. Fake outs, one data set, a non-matching data set, and if it's not obvious, there's a discrepancy. One of these is not like the other, and the wrong one exists before, right? On May 5th, there are more shares than there should be on May 9th. So what was the purpose, right? Because then later, all of a sudden, it's fixed. So in my opinion, and I wonder, and I'm not alleging anything, I'm just sharing my non-professional opinion, were their actions made to try and indicate one direction as a fake out versus another direction to see what would happen? Maybe. Is this related to the ASR? Is this related to share lending practices, repurchases, share shorting? I don't know. But you can't deny that there are too many shares, and they have a documented evidentiary record of there being an oopsie. Now, we spoke at the beginning about how qualified the attorneys are that work for Kirkland and Cole Schatz, and that these are professionals of the highest degree. Kirkland in 2023 being the largest law firm in the world by revenue. A fun fact that I don't know why I know. By July 20th, this discrepancy in the share count is fixed. Now, I will assume that to become an attorney charging $1,500 an hour, working for the largest law firm in the world, you have to have some desire in you to chase and to be successful and to want to bring to justice and represent your client to the best of your ability. I don't think that the attorneys at Kirkland and Cole Schatz and the other debtor professionals involved would have just decided, oh man, this is really problematic. Let's just pretend it didn't happen. In my opinion, this is a main part of the third-party release. It is the settlement of the accounting discrepancy and the discrepancy of the shareholder ledger. That's just my opinion. Talked about it before. The July 20th date is no coincidence as well. It's immediately 2 days after the first draft of the first plan that states that the third-party release, whatever. Don't want to get too tangential because this video already I can tell is going to be too long. But again, just to highlight, right? If the company is in the level of distress that they were, that we know that they were because it was widely publicly reported, why did they only take $225 million from their new lifeline, right? Why did Sixth Street expand their credit facility by $100 million at the same time? Was it because they had to maintain percentage ownership of a certain specific alignment, right? Much like the bond exchange into shares by the individual investor that added $3 million on top of their bonds for more shares. Talked about that Lazard thing and my thoughts on mid-late January in a previous video, so let's not go there. Talked about overstock. So why would you only pull that much money from HBC? Well, the 10K did not shy away from making some very specific claims, which I think are very, very exciting, really, really important to bring back into the conversation and brainstorm together as a group, because what a statement. When the company was in distress, they determined that the offering through HBC was not an orderly transaction. Not an orderly transaction. And the gross proceeds did not represent fair value. Right? They go on to explain that, you know, how they came up with their value model for how they knew, and they have a record here, not only in the court record, right, in the legal record of the federal court, but they also have a record with the regulator filed in a financial disclosure statement of a publicly traded company that they had a big loss. Combine that with this discrepancy, and I think the goal here should be very clear. As I've talked about in the past in detail, the third-party release, the asset sale transaction, the bringing to account the ASR, the October 2020 plan, in my opinion, allegedly, not making any factual claims. And I just want to end this on a bit of an eye-opener, jaw-dropper, whatever you want to call it, because although much of my focus has been on the ASR, right, because as I've said many times, I believe it's a big piece of the third-party release. It might even be the main piece of the third-party release. There's something else that I found that I think is really, really, really striking, and I never saw it before. And it has to do with decision-making at this company through many boards. I mean, this transcends multiple board members and multiple board compositions, but there are two consistent elements: the investment banks. You may remember this from a previous presentation that we did. This was the first activist shareholder campaign by Misellum and Legion Partners, managed by Olshan, with Elizabeth Sussman, famously the Sussman NDA. That was a fantastic find in the past. But I want to focus not so much on this, because we went over the details of this in the settlement, because the activists were actually suing the company. I want to focus on the bottom, right? So looking back here, Goldman Sachs is acting as the financial advisor to Bed Bath & Beyond, which we know continued alongside JP Morgan when they were making the October 2020 plan, because this is disclosed in the minutes as filed by the plan man in that giant $2.5 billion lawsuit against the board members for their alleged financial misconduct, which was settled. Goldman Sachs is acting as the financial advisor to Bed Bath & Beyond in 2019, right? Okay. Knowing everything you know that we talked about, the share repurchases, the October 2020 plan, and the ASR, would you not believe that July 17th, 2014, the day that this company announces the closing of their bond indenture, having raised $1.5 billion, on the same day, in parallel, they announced that they have entered into an ASR with their financial advisor and investment bank, Goldman Sachs at the time, to repurchase $1.1 billion of the company's stock. The same day that they took on $1.5 billion of debt to have cash to who knows do what. And if you're familiar with the 2019 activist campaign, they famously say that since 2015, the company never had a stock price appreciation. They say as of 2015 or 2014 or 2015, things were going down in the gutter. And look at that. Of all of their $1.5 billion that they raise, and they place liens on their assets, right? They are now, really in a structured kind of creditor setup where they have negative covenants, positive covenants pursuant to a bond indenture. On that same day, they take 1.1 of that $1.5 billion and, hamstring themselves into an ASR with Goldman, who is still the financial advisor of the company in 2020. Isn't that something? No stranger to allegedly, my opinion, poor decision making. I hope you enjoyed it. I hope you found this video helpful. I hope it came at a good time and you found it informative. Love to hear your thoughts. Thanks for listening, and until next time.